In modern usage, a magistrate is a judge or lawyer who hears cases in courts. In the United Kingdom, the term magistrate usually refers to a volunteer of the Magistrates Courts. Historically in Canada, magistrates were retired police officers, but they are now lawyers appointed by the lieutenant-governor-in-council. Canadian magistrates are known today as provincial court judges. They are judicial officers with summary jurisdiction in both criminal and civil actions, hearing minor indictable offences and those cases where the accused may elect the mode of trial. They may preside over family court, a small claims court, and are ex officio commissioners for oaths. In the United States, magistrate judges are appointed to assist United States District Court judges in the performance of their duties. Magistrate judges are authorized by 28 U.S.C. Section 631 ASEQ. The position of magistrate judge, or magistrate, also exists in some unrelated state courts. U.S. magistrate judges generally oversee first appearances of criminal defendants, set bail, and conduct other administrative duties. Formerly in ancient Rome, a magistrate was one of the highest-ranking government officers, and possessed both judicial and executive powers. Today, in common law systems, a magistrate has limited law enforcement and administration authority. In civil law systems, a magistrate may be a judge in a superior court, where the magistrates' court might have jurisdiction over civil and criminal cases. A related, but not always equivalent term, is chief magistrate, which historically can denote a political and administrative officer. Etymology: magistrate derives from the Middle English word magistrat, denoting a civil officer in charge of administrating laws, from the Old French magistrat, from the Latin magistratus, which derives from magister, from the root of magnus. Original meaning: in ancient Rome, the word magistratus referred to one of the highest offices of state. Analogous offices in the local authorities, such as municipium, were subordinate only to the legislature, of which there generally were members. Ex officio, often a combination of judicial and executive power, constituting one jurisdiction. In Rome itself, the highest magistrates were members of the so-called cursus honorum, career of honors. They held both judicial and executive power within the sphere of responsibility, and also had the power to issue a U.S. honorarium, or magisterial law. The consul was the highest Roman magistrate. The praetor was the highest judge in matters of private law between individual citizens, while the curule aediles, who supervised public works in the city, exercised a limited civil jurisdiction in relation to the market. Roman magistrates were not lawyers, but were advised by jurists who were experts in the law. The term was maintained in most feudal successor states to the Western Roman Empire. However, it was used mainly in Germanic kingdoms, especially in city-states, where the term magistrate was also used as an abstract generic term denoting the highest office regardless of the formal titles. Even when that was actually a council, the term chief magistrate applied to the highest official in sovereign entities, the head of state and/or head of government. Continental Europe and its former colonies. Under the civil law systems of European countries such as Belgium, France, and Italy, magistrata magistrato is a generic term which comprises both prosecutors and judges. In Portugal, besides being used in the scope of the judiciary to designate prosecutors and judges, the term magistrado was also used to designate certain government officials, like the former civil governors of district. These were referred as administrative magistrates, to distinguish them from the judiciary magistrates. The President of Portugal is considered the supreme magistrate of the nation. In Finland, Magistrate is a state-appointed local administrative office whose responsibilities include keeping population information and public registers, acting as a public notary, and conducting civil marriages. Mexico In Mexico's federal law system, a magistrado is a superior judge, hierarchically beneath the Supreme Court justices. The magistrado reviews the cases seen by a judge in a second term if any of the parties disputes the verdict. For special cases, there are magistrados superiors who review the verdicts of special court and tribunal magistrates. English common law tradition. United Kingdom, England and Wales. In the courts of England and Wales, magistrates, also known as justices of the peace, are volunteers who hear prosecutions for and dispose of summary offences and some triable either way offences by making orders with regard to and placing additional requirements on offenders. Magistrates, JPs, are limited to issuing sentences to longer than 6 months for one offence and up to 12 months consecutively for multiple offences. Magistrates, JPs, have other limitations in the sentencing authority, with powers extending to a maximum of a £5,000 fine. Community orders, which can include curfews, electronic tagging, are requirements to perform unpaid work up to 300 hours, and supervision for up to 3 years. In more serious cases, magistrates can send either way offenders to the Crown Court for sentencing when the magistrate feels a penalty should be imposed that is more severe than the magistrate is capable of sentencing. A wide range of other legal matters is within the remit of magistrates. In the past, magistrates have been responsible for granting licenses to sell alcohol, for instance, but this function is now exercised by local councils, though there is a right of appeal to the Magistrates Court. Magistrates are also responsible for granting search warrants to the police and other authorities. Therefore, it used to be a requirement that they live within a 15-mile radius of the area they preside over in case they are needed to sign a warrant after hours. However, commission areas were replaced with local justice areas by the Courts Act 2003, meaning magistrates no longer need to live within 15 miles, although, in practice, many still do. Section 7 of the Courts Act 2003 states that there shall be a Commission of the Peace for England and Wales. Be addressed generally, and not by name, to all such persons as may from time to time hold office as Justices of the Peace for England and Wales. Thus, every magistrate in England and Wales may act as a magistrate anywhere in England or Wales. There are two types of magistrates in England and Wales: Justices of the Peace and district judges who hold office as members of the professional judiciary. According to requirements, around 50% of magistrates are women. Over 41% of magistrates are retired from employment, while others may be self-employed or able to arrange leave from their employment. No formal qualifications are required, but magistrates require intelligence, common sense, integrity, and the capacity to act fairly. Membership is widely spread throughout the area covered and drawn from all walks of life. Police officers, traffic wardens, and members of the armed forces, as well as their close relatives, will not be appointed, nor will those convicted of certain criminal offences, including recent minor offences. All magistrates receive 3 days of training before sitting, carried out in conjunction with a mentoring program, which covers basic law and procedure. They continue to receive training throughout their judicial career. Additional training is given to magistrates choosing to sit in the youth court or those dealing with family matters. New magistrates sit with mentors on at least 6 occasions during the first 18 months. Magistrates are unpaid appointees, but they may receive allowances to cover traveling expenses, subsistence, and loss of earnings for those not paid by their their employer while sitting as a magistrate, up to £116.78 a day. A justice of the peace may sit at any magistrates' court in England and Wales, but in practice, they are appointed to the local bench and are provided with advice by a legally qualified clerk to the justices. They will normally sit as a panel of 3 with 2 as a minimum. Many are members of the Magistrates Association, which provides advice and training and represents the approximately 28,000 magistrates to the government. The association also represents magistrates on the Sentencing Guidelines Council. Members of the second group are known as district judges. Unlike magistrates, district judges sit alone. They are appointed by open competition through process administered by the JAC and are required to be qualified solicitors, barristers, or chartered legal executives. Some also sit in the family court. Questions have been raised by the Magistrates Association as to the legal safeguards of a single district judge allowed to hear a case, decide the outcome, and pass sentence without reference to another party. Scotland. In Scotland, the lowest level of law court, the Justice of the Peace Court, is presided over by a Justice of the Peace. The office of Stipendiary Magistrate was established by the District Courts Act 1975, and is due to be abolished by the Courts Reform Act 2014. Stipendiary magistrates are ex officio justices of the peace, and when sitting in a JP court also have the summary criminal jurisdiction and powers of a sheriff. Australia. Federal Magistrate. A federal magistrate occupies an office created in 1999. The Federal Magistrates Court of Australia deals with more minor Commonwealth law matters, which had previously been heard by the Federal Court of the Family Court. The court's name is misleading, in that it exercises a jurisdiction well in excess of that of the state magistrates' courts, and similar to that of the district and county courts of the Australian states. The federal and family courts continue, but the federal magistrates hear shorter or less complex matters are matters in which the monetary sum in disputes does not exceed given amounts. For instance, property divisions where the total assets are $700,000 or less, and consumer law matters where the amount claimed is less than $750,000. However, in some areas, such as bankruptcy and copyright, the court has unlimited jurisdiction. The Federal Magistrates Court has assumed a significant part of the workload of the two superior courts. By May 2004, the court was dealing with 73% of the total number of applications made in the three courts. State Magistrate. The state magistrates in Australia derive from the English magistrates. All magistrates are salaried officers. The jurisdiction of the magistrates varies from state to state. They preside over courts which are, depending on the state, called magistrates' courts, local courts, or courts of petty sessions. Magistrates hear bail applications, motor licensing applications, applications for orders restraining a given individual from approaching a specific person, summary criminal matters, the least serious indictable criminal matters, and civil matters where the disputed amount does not exceed $40,000 to $100,000. In some states, such as Queensland and NSW, the magistrate may appear robed, although some magistrates are known to prefer a business suit. Magistrates presiding in the Koori Court were originally of a mind not to appear robed. However, elders within the indigenous community urged magistrates to continue wearing robes to mark the solemnity of the court process to defendants. Robing is being considered for magistrates in other states. However, Neither counsel nor solicitors appear robed in any Australian magistrates' court. Robing in summary courts is unlikely to extend to the legal profession. Historically, magistrates in Australia have been referred to as Your Worship. However, members of the magistracy are now addressed as Your Honour in all states. This was partly to recognise the increasing role magistrates play in the administration of justice, but also to recognise the archaic nature of Your Worship, and the tendency for witnesses and defendants to incorrectly use Your Honour in any event. It is also acceptable to address a magistrate simply as Sir or Madam. Hong Kong. There are currently 7 magistrates' courts in Hong Kong. Magistrates exercise criminal jurisdiction over a wide range of offences, although there is a general limit of 2 years imprisonment or a fine of $100,000. Certain statutory provisions give magistrates the power to sentence up to 3 years imprisonment and to impose a fine up to $5 million. India. There are 4 categories of magistrates in Judiciary of India. This classification is given in the Criminal Procedure Code, 1973. It stipulates that in each Sessions District there shall be Chief Judicial Magistrate, Subdivisional Judicial Magistrate, Judicial Magistrates First Class, Executive Magistrates. 1. Chief Judicial Magistrate includes additional Chief Judicial Magistrates, CJMs. Hear all types of criminal cases. All magistrates' courts are controlled by the CJM. The CJM looks over the work of judicial magistrates, but cannot take any action against them. The CJM can only report the misbehavior of judicial magistrates to the High Court. A court of chief judicial magistrates can sentence a person to jail up to 10 years and impose fines of up to 30,000 rupees. The CJM is senior among all magistrates in the district. 2. There is a subdivisional judicial magistrate in every subdivision. They hear cases related to the Dowry Act, EC Act, and other criminal cases. They also maintain and control the judicial court below them. A court of subdivisional judicial magistrates may sentence a person to fines of up to 10 years and impose fine up to 25,000 rupees. Judicial magistrates can try criminal cases. 3. A judicial magistrate first class can sentence a person to jail for up to 7 years and impose a fine of up to 15,000 rupees. 4. An executive magistrate is an officer of the executive branch who is invested with specific powers under both the CRPC and the Indian Penal Code. These powers are conferred by Sections 107 to 110, 133, 144, 145, and 147 of the CRPC. These officers cannot try any accused nor pass verdicts. A person arrested on the orders of a court located outside the local jurisdiction should be produced before an executive magistrate who can also set the bail amount for the arrested individual to avoid police custody, depending on the terms of the warrant. The executive magistrate also can pass orders restraining persons from committing a particular act or preventing persons from entering an area. There is no specific provision to order a curfew. The executive magistrates alone are authorized to use force against people. In plain language, they alone can disperse an unlawful assembly. Technically, the police are to assist the executive magistrate. Executive magistrates can dictate to the police the manner of force and also how much force should be used. They can also seek the assistance of the armed forces to quell a riot. Each district contains the following judicial magistrates: Chief Judicial Magistrate, 1 or 2 additional Chief Judicial Magistrates, 1 or 2 subdivisional judicial magistrates, 5 judicial magistrates first class. There are, in each revenue district, the following kinds of executive magistrates: district magistrate, 2 or more additional district magistrates, 4 or more subdivisional district magistrates and at least 10 executive magistrates. All the executive magistrates of the district, except the ADM, are under the control of the DM. These magistrates are normally conferred on the officers of the Revenue Department, although an officer can be appointed exclusively as an executive magistrate. Normally, the collector of the district is appointed as the DM. Similarly, the sub-collectors are appointed as the SDMs. Tehsildars and deputy additional tehsildars are appointed as executive magistrates. Under the old CRPC, there was no distinction between the executive and judicial magistrates. Some states still follow the old CRPC. Bangladesh. According to the Code of Criminal Procedure 1898, there are 2 classes of magistrates in Bangladesh, namely, judicial magistrate and executive magistrate. There shall be 4 classes of judicial magistrate, namely, Chief Metropolitan Magistrate in Metropolitan Area and Chief Judicial Magistrate to other areas. Magistrate of the first class, who shall in Metropolitan Area, is known as Metropolitan Magistrate. Magistrate of the second class, Magistrate of the third class, Executive Magistrate. According to the Section 10 of the Code of Criminal Procedure 1898, members of Bangladesh Civil Service cadre, who are in the capacity of Assistant Commissioner, Upozila Nirbahi Officer, and Additional Deputy Commissioner shall be executive magistrates and may exercise the power of executive magistrate within their existing, respective local areas. Besides this, according to the provision of the Section 10 of CRPC 1898, the government may, if it thinks it expedient and necessary, appoint any persons employed in the Bangladesh Civil Service to be an executive magistrate and confer the powers of an executive magistrate on any such member. Every administrative district has the following executive magistrates: District Magistrate. In every district and in every metropolitan area, the government shall appoint as many persons as it thinks fit to be executive magistrates and shall appoint one of them to be the district magistrate. Additional district magistrate. The government may also appoint any executive magistrate to be an additional district magistrate. Additional district magistrates shall have all or any of the powers of a district magistrate under this code or under any other law for the time being in force, as the government may direct. Additional Deputy Commissioner. All the ADCs in the district are executive magistrate. Upozila Nirbahi Officer, a Sub-District Executive Officer, Assistant Commissioner, including Senior Assistant Commissioner and Assistant Commissioner. New Zealand. The position of Stipendiary Magistrate in New Zealand was renamed in 1980 to that of District Court Judge. The position was often known simply as Magistrate, or the post-nominal initials EDM after a magistrate's name in newspapers' court reports. In the late 1990s, a position of Community Magistrate was created for district courts on a trial basis. Under this system, 2 community magistrates were initially required to sit to consider a case. Some of these community magistrates are still serving. United States. Magistrates are somewhat less common in the United States than in Europe, but the position does exist in some state jurisdictions and in federal courts. The term magistrate is often used as a generic term for any independent judge who is capable of issuing warrants, reviewing arrests, etc. When used in this way, it does not denote a judge with a particular office. Instead, it denotes a judicial officer who is capable of hearing and deciding a particular matter. That capability is defined by state statute or by common law. In Virginia, for example, the Constitution of 1971 created the office of magistrate to replace the use in cities and counties of the justice of the peace, which is common in many states for this function. As noted above, the terms magistrate or chief magistrate were sometimes used in the early days of the Republic to refer to the President of the United States, as in President John Adams's message to the U.S. Senate upon the death of George Washington. His example is now complete, and it will teach wisdom and virtue to magistrates, citizens, and men, not only in the present age, but in future generations, as long as our history shall be read. Federal courts in the United States. Federal courts. A magistrate judge is a judicial officer authorized by 28 U.S.C. Section 631 A.SEQ. They were formerly known as U.S. Commissioners, and then as magistrates. Magistrate judges, as they have been designated since 1990, are appointed by the life-term federal district judges of a particular court, serving terms of 8 years if full-time, or 4 years if part-time, and may be reappointed. Magistrate judges conduct a wide range of judicial proceedings to expedite the disposition of the civil and criminal caseloads of the United States. District courts. Congress set forth in the statute the powers and responsibilities that could be delegated by district court judges to magistrate judges, to achieve maximum flexibility in meeting the needs of each court. However, Congress left to the individual courts the actual determination of which duties to assign to magistrate judges. State courts. In many state court systems in the United States, magistrate courts are the successor to justice of the peace courts, and frequently have authority to handle the trials of civil cases up to a certain dollar amount at issue, applications for bail, arrest and search warrants, and the adjudication of petty and misdemeanor criminal offenses. In Ohio, magistrates are subordinate to the judges who appoint them, and all of the decisions are subject to the review, amendment, approval, or reversal by a judge. In some states, including West Virginia and Georgia, magistrates are elected and not appointed. Other traditions. China magistrate, or chief magistrate, is also a common translation of the Chinese xiangzhang, the political head of a county xian, which ranks in the third level of the administrative hierarchy of China. The translation dates from Imperial China, in which the county magistrate was the lowest official in the Imperial Chinese bureaucracy and had judicial in addition to administrative functions. In modern-day China, the county leader is technically elected by the local People's Congress but, in fact, is appointed by the Communist Party. Although there have been some elections at the lower township level, these elections have not extended up to the county level. Although not an important official, county leaders, particularly in rural areas, can sometimes have a strong impact on the lives of ordinary people by enforcing central government regulations or by turning a blind eye to their violation. Switzerland. In Switzerland, magistrate is a designation for the persons holding the most senior executive and judicial offices. On the federal level, the members of the Federal Council, the Federal Chancellor, and the judges on the Federal Supreme Court are called magistrates. The designation of magistrate is not a title or style. It does not by itself confer any particular privileges. Taiwan. In Taiwan, magistrates are the heads of government of counties. The county magistrate elections are heavily and sometimes bitterly contested, and are often a stepping stone to higher office. County magistrate elections were first open to election in the 1960s and, before the end of martial law in 1991, were the highest elected position of any real power, and hence, the focus of election campaigns by the Tangwai movement. Kenya. In Kenya, there are 5 categories of magistrates, namely resident magistrate, senior resident magistrate, principal magistrate, senior principal magistrate, and chief magistrate. Chief Magistrate is the highest of magistrates and also assumes administrative control of magistrate courts in his or her jurisdiction. Chief Magistrate has jurisdiction in disputes that does not exceed 7 million Kenya shillings. Senior Principal Magistrate dispute not exceeding 5 million Kenya shillings. Principal Magistrate dispute not exceeding 4 million Kenya shillings. Senior Resident Magistrate not exceeding 3 million Kenya shillings and Resident Magistrate dispute not exceeding 2 million Kenya shillings.